we get started, I would just like to remind everyone that this is a joint work session between we, your commissioners, and the Plan Commission. There will be a lengthy presentation by the staff. They'll be explaining where we are in regards to the Michigan law. At this point, this is not a meeting for public comment. Public comment meetings will be taking place next week and the following week, and at that point you can state your opinion for the record, whether your concerns, your questions. But tonight, this is focusing on the law. We'll be learning all about the Michigan medical marijuana law and how it relates to what we could or could not decide to do in Buchanan. Most of it will be a presentation from our state representative's office, as well as our city attorney, as well as city staff. If at any point you have a question, we have provided forms and pens by the door. You are more than welcome to write down any question that you have regarding the law. Tonight, this is an educational meeting about the law only. We're really not seeking public comment at this point. Now, if you cannot attend any of the public comment meetings, we would appreciate you sending us emails. Our email addresses are listed at our city website, which is thecityofbuchanan.com. If you need my personal email address, I have business cards, and I will be available after the meeting, and you can get a card from me as well as probably the rest of the commission. So I just wanted to make sure if you came tonight to express your opinion, that's not what we're not here for tonight. This is just education about the law and what the law means, because that's a very important part of this process. But we also feel very strongly that we want citizens' input one way or the other. We want to ask you your questions. We want this to be a very transparent process, and we are planning on having this particular proceeding published or available for view on Channel 17 here in town if you have cable TV. So I just want to clarify, if you have questions about the law, would you like me to have them bring them up to you, or would you like to?
If they just place them in the basket.
Okay, there's a basket at the back. You can just write out your question. And if you would like us to contact you personally about your issue, question about the law, please make sure you put a way for us to do that at the bottom. And once again, we are available phone calls and emails too. Thank you.
What day are you going to be available for public comment, did you say?
Next week, we'll announce that at the end of the meeting. Okay. So yes, we're going to make sure that everyone knows. We'll probably be putting it on the city's Facebook page as well.
Thank you.
Okay? Thank you. I think we're all set. Okay, well, I gotta wait for Bill though. Thanks, Joe.
We got some seats over here if you'd like to sit down in seats.
You all set? Okay. My name is Mayor Brenda Hess, and I would like to call to order the City of Buchanan City Commission and Planning Commission joint work session. Today is Tuesday, February 7th, 2017, and we are starting at 7 p.m. Our first item on our agenda this evening is a call to order, and then we're going to take roll call.
Cole? Here. Moore?
Here.
Tarney?
Here.
Hess?
Here.
Bianski?
Yes.
You have a quorum, Your Honor.
Thank you. Could we have the Planning Commission people please announce their names, please, and introduce themselves?
Dale Turney. I'm on the Planning Commission also.
Dale wears two hats, so. All right, and we've kind of already had an introduction of the House rules. Just a reminder that public comments from the floor will not be taken tonight unless
Got
you
some
fill
seats up here.
out the form. And please, if you could not block the door for fire regulations, we would really appreciate it. You can return your question about the law to the basket in the back, and we'll try to address as many of those as we can at the conclusion of this meeting. This meeting should last 90 minutes. We plan on concluding the meeting at 8:30. Okay? And I think we're up to item number 4. We are ready to hear from the city attorney.
Good evening, everyone. My name is Rick Rock. I'm an attorney with Bittner Jennings. I am the assistant city attorney. Randy Hearns is the city attorney and has been now for a long time. I want to thank the city commission, the mayor, and the planning commission, and all of you for coming out tonight. The purpose of this meeting is to provide some information to not only the city, but to the citizens in an area that is up and coming and is essentially knocking on the door for every municipality in Michigan. In 2008, Michigan, by an overwhelming majority, passed the Michigan Medical Marijuana Act. We've all heard, I think, caregivers, patients, dispensaries. There's questions as to what's legal, what isn't legal, what can a city do, what can a patient do, what can a caregiver do, what are those, what is a dispensary, and moving forward, because of the ambiguities and that comes with every new law, there have been some trials and tribulations since 2008. So in 2016, Michigan again passed an amendment to the Medical Marijuana Act, which is hoped to provide some clarification to some ambiguities. It has, in addition, passed 2 additional acts. December 15th of 2016 was signed into law. The Michigan Medical Facilities Licensing Act and then the Michigan Tracking Act. Now, those 2 laws, while take effect in December of 2016, they do not become operative until December of 2017. So we've got 10 months or so before any municipality in Michigan can do anything or any citizen or Michigan entity can become registered with the state of Michigan. Now, the applications will be filed for several different areas, but not again until December 15th, 2017. So I prepared a slideshow with the help of the city with an overview, again, of starting off with the federal regulations of marijuana. Now, marijuana is still a Schedule I restricted drug, which means that marijuana is still illegal. It is the federal government and a state who does not provide for some provision, marijuana is illegal. It's a Class I scheduled drug, and there are several areas where we've got, in 2016, the DEA rejected a petition to reclassify marijuana out of that Schedule I. The FDA has even warned aid to companies to stop making claims about the medicinal benefits and products that include compounds in marijuana, and legislation introduced at the federal level to remove marijuana has not passed to date. However, Michigan has, with these 3 acts, provided some exemptions from the law. Now, a lot of questions, how can the state do something that is in contradiction to federal law? The state is afforded can allow additional rights than what the federal government can provide. If state law imposes more responsibility on its residents than the federal law, the state law prevails unless those laws are in explicit conflict. Now, the new, can we go back one? Just so again, the summary of the Medical Marijuana Acts in Michigan, the Facilities Licensing Act, the Tracking Act, and the, again, the original Medical Marijuana Act. So, the Medical Marijuana Facilities Licensing Act, this is what passed in 2016 in December, does not legalize marijuana. All right, licensees who are licensees, registered qualifying patients, registered primary caregivers will receive specified protection from the marijuana-related criminal or civil prosecutions. Again, if they are in compliance with the acts. And just a quick update or side note, we're going to see Laura and the board frequently in the slideshows. Laura is Michigan's Department of Licensing and Regulatory Affairs, and the board is the newly appointed or created medical marijuana board that is going to be fielded with board members from the governor. So the purpose of the legislature that they found that the necessity for access to safe sources of marijuana for medical use and the immediate need for growers, processors, secure transporters, provisioning centers, and safety compliance facilities to operate under clear requirements to establish the need to, they found that because of Michigan's medical marijuana law, we've got caregivers and we've got patients, we had no way of providing them with the marijuana in an effective, safe method. They've provided this exemption for medical marijuana, but no clear way of how to enforce it, how to get it out in a manner that is easily enforceable and there to make sure that it's done so in a safe manner. Hence, the two new acts and the amendments to the old law. So we create the Medical Marijuana Licensing Board. It's a 5-member board appointed by the governor. It grants a broad general responsibility for administering, implementing, and enforcing the act. And again, we have the Marijuana Advisory Panel, which is a 17-member panel within Laura to make recommendations to Laura and the board. The problem that we have right now is Laura, who is deemed to be responsible for providing the administrative rules, hasn't done that yet. So we're in a holding pattern because a lot of the administrative rules will help municipalities draft and formulate the regulations within their own individual communities for how they want to implement, if they choose, the new medical marijuana laws. Okay, so why we're here today. The new laws allow the municipalities such as Buchanan, Niles, any other community, city, township, village within the state to opt in to the new medical marijuana laws. So this is not a provision where that it requires, if Buchanan or any other municipality chooses not to do anything, then the new laws do not take effect in that local community. If Buchanan chooses to do nothing within the city limits, the licenses that are available under Laura will not be permitted in that municipality. The municipality does not have to act. They do not have to allow for this. But it allows the municipality to adopt an ordinance authorizing one or more facility types. It allows the municipality to limit the number of each type and to establish an annual license fee not exceeding $5,000 to help defray associated administrative and enforcement costs. Now, those fees can't be a blanket fee. It says, it allows for a fee not to exceed $5,000. The fee must be commensurate with the amount it costs to enforce your zoning. You just can't be a blanket fee, and the municipality is going to have to track its costs in order to justify that fee. All right. So, again, the Act requires the license applicants to provide the board with a copy or website posting referencing a reference for the municipal ordinance and the zoning regulations. So that means it's going to require the applicants to provide Lansing with a copy or a website regarding whether or not the municipal ordinance or zoning regulations even exist. It's going to require the license applicants to give notice of the application that they are filing with the state, to give that notice to the municipality by registered mail within 10 days of filing the application with the state. And then within 90 days after a municipality receives that notification from the applicant, the municipality then must provide all the following documents to the licensing board in Lansing. So a copy of the local ordinance authorizing the marijuana facility and the zoning regulations that apply to that proposed facility, a description of any violation of the local ordinance or zoning regulation described above committed by the applicant, but only if the violations relate to the activities licensed under the Act. So the Act creates 5 license categories. And we've got grower, and within that grower license, there are 3 subcategories: Class A, Class B, and Class C. Now, Class A grower, you're allowed a maximum of 500 plants. Class B, a maximum of 1,000 plants, and Class C, a maximum of 1,500 plants. Now, currently, under Michigan's Medical Marijuana Act, a patient, I believe, can have up to 12 plants. And a caregiver, I believe under the new amendments, a caregiver is allowed to have up to 5 patients, and the patient can then assign their rights to the caregiver to handle those 12 plants. So the caregiver can have up to 60 plants. So again, this is quite a, it's quite an increase. The next license is the processor, which is a commercial entity that creates edibles, topical treatments, and beverages, anything really that's not inhaled by smoke. Edibles, things you eat, food. I don't want to say brownies because that was too easy, right? We've got a provisioning center, which I think most everyone understands or calls a dispensary, the retail side. Secure transporter, and then the safety compliance facility. All right, so the grower. So growers are a commercial entity, and a growers really cultivate, dry, trim, or cures and packages medical marijuana. Growers operate in an area zoned only for industrial or agricultural uses within the municipality, or I suppose in an area that is unzoned and authorized by the municipal ordinance. Not many areas in Michigan that go unzoned. So we're really, I think, stuck with the industrial or agricultural zoned areas for a grower. Sales of marijuana seeds or plants from the grower can only go to another grower by means of a secure transporter. And we'll talk about a secure transporter a little later. Sales of marijuana other than seeds can be made only to a processor or provisioning center by a secure transporter. So growers can only sell seeds to other growers and marijuana other than seeds only to a processor, or provisioning center. So again, all of those are licensed under the state. The licensed applicant and each investor in the grower must not have an interest in the secure transporter or a safety compliance facility. Now you're going to see, and some of you who own bars or restaurants or other areas that deal with the Michigan Liquor Control Commission, you're going to see a lot of similarities between the marijuana and the liquor control. We've got a lot of areas where we have different types of licenses, and like the liquor control, you're going to see a separate system. They're going to make sure that someone who is a processor doesn't have any interest in a secure transporter. They don't want to, or vice versa, they don't want a grower and a processor. They want to keep everything separate and segregated so that they keep any issues of conflict or ability to take advantage of the system. The statute that they're putting in place is really guided in an effort to make sure that the system stays pure and to the intent of the legislators. A grower, until December 31st of 2021, has to have a minimum of 2 years experience as a registered primary caregiver or have an active employee with that experience. They just don't want anyone starting to grow without any experience, I think for obvious reasons. A grower can't be registered as a primary caregiver and again not employ an individual who is a current registered primary caregiver. Again, they're trying to keep everything separate and segregated so that we protect the process as best as possible. So all transactions from a grower, current inventory, and other information into the statewide monitoring system that will be created need to be so we'll talk about the monitoring system in a little bit. So the grower is going to be required to provide all this information onto an electronic database that will that the state will have access to and will be able to track from seed to patient. Every batch, plant, product will be tracked from seed to patient or to destruction.
Well, it's slow.
Okay. Well, we'll just continue on. The next license here we go, the processor. Again, this is a commercial venture. The processor extracts resin from marijuana and creates marijuana-infused product for sale and transfer in a packaged form to a provisioning center or a dispensary. The processor license authorizes the purchase of marijuana only from a grower and sale of marijuana-infused products only to a provisioning center. A processor only transports via a secure transporter. Again, no interest in a secure transporter or safety compliance facility when you have a processor license. And again, until December 31st, 2021, you have to have a minimum of 2 years experience as a registered primary caregiver or have an active employee with such experience. Can't be a registered primary caregiver and can't employ a current registered caregiver. And again, the processor must enter all of its transactions, current inventory, and any other information into the statewide monitoring system and the Tracking Act. So, provisioning center license. So this, technically, I mean, it's not a dispensary. There's no mention of the word dispensary in the statute. Never has been, but it's a popular term, but it is a provisioning center. This license authorizes the purchase and sale of marijuana only from a grower or a processor, and sale and transfer to only a registered qualifying patient or a registered primary caregiver. All transfers of marijuana to a provisioning center from a separate marijuana facility must be by means of a secure transporter. This license authorizes the transfer of marijuana to or from a safety compliance facility for testing by means, again, of a secure transporter. The applicant and each of its investors must not have an interest in the secure transporter or safety compliance facility. And this license also allows these for the sale or transfer to a patient or caregiver only after that marijuana has been tested and bears the label required for retail sale. And this is something that I just picked up, a non-commercial location used by a primary caregiver to assist a qualifying patient connected to the caregiver through the department's marijuana registration process is not a provisioning center. So if you've got a primary caregiver who is connected to a patient, just because of that situation, he's not covered under the Act, he's not licensed, and therefore he's still subject to the original Michigan Medical Marijuana Act, and again, is not doing this for anything other than under that original act, and is not licensed under the state. Again, all transactions, current inventory, any other information need to be entered into the statewide monitoring system. A check of the statewide monitoring system before selling or transferring marijuana to a patient or caregiver on behalf of a patient to determine whether the patient and, if applicable, the caregiver hold a valid, current, unexpired, unrevoked registry identification card, and that the sale or transfer will not exceed the daily purchasing limit established by the board. So under the original 2008 Act and its amendment, to be a caregiver or a patient, let's start. To be a patient, you have to go see a doctor. You have to have a debilitating disease that can be treated either for pain purposes through marijuana, and there's a list of specific diseases: cancer, glaucoma, HIV, hepatitis C. Those are some of a few of those listed. If you have a doctor willing to write it's not a prescription. You can't write a prescription for marijuana because it's still a controlled one substance. If he's willing to write up a prescribed form, you are then allowed to, the patient is then files their application with the state. The state then will either grant the application or deny it. If you are granted the license, they send you a card within 5 days, and along with that card and your driver's license or a valid photo ID, you are a qualified patient, and then you may avail yourself to the immunities under the Medical Marijuana Act. The caregiver likewise has to be licensed or registered with the state, and under this provisioning center, an owner of a provisioning center will have to hop on this statewide system and ensure that before they sell to a patient or a caregiver, that these individuals have valid licenses, they are not revoked, and they will be able to tell whether or not that individual will be violating the daily purchasing limit that's going to be established by the board. Again, this daily purchasing limit has not been established yet. I believe we're waiting on that from Laura. Provisioning centers cannot cannot provide alcoholic beverages on the premises for sale or consumption. Again, you can't. They will not be allowed to have a physician conducting a medical examination or issuing a medical certification document on the premise for the registry identification care purposes. The secure transporter license, again, this is a commercial entity for a fee. This allows the licensee to store and transport marijuana and money associated with the purchase or sale of marijuana between facilities, again, for a fee upon the request of a person with the legal custody of marijuana or money. Again, so the legal custody of marijuana or money is a licensee, either a provisioning center, a grower, or a processor. It does not authorize the transport to a patient or caregiver. This is strictly transportation between the licensees. The secure transporter must have a Michigan chauffeur's license. Each employee must not be convicted of or released from incarceration for a felony under Michigan, federal or other states' laws within the past 5 years, or convicted of a misdemeanor involving a controlled substance within the past 5 years. Two-person crews are required to operate each vehicle, with one remaining in the vehicle at all times. A route plan and manifest must be entered into a statewide monitoring system, and a copy carried and presented to law enforcement upon request. The product must be transported in one or more sealed containers that is not accessible while in transit, and the vehicles are to be unmarked or have other indications it is carrying marijuana or a marijuana-infused product. The safety compliance facility, again, a commercial entity which authorizes the transfer and testing of marijuana from a caregiver as authorized under the Act. It authorizes the facility to receive marijuana from, test it for, and return it to only the marijuana facility in which it originated. This licensee must be accredited by an entity approved by the board in Lansing by 1 year after the date of the license is issued, or that has previously provided drug testing services to the state or the state court system, and be a vendor in good standing in regard to those services. So again, they're trying to provide some quality control in the safety compliance license. While it does allow for a variance from this requirement upon a finding that the variance is necessary to protect and preserve the public health, safety, or welfare. Again, these laws, without being on the books for very long and not taking effect until December of 17, we don't have a lot of experience with how these laws are going to affect real life. So until we have a little more input, the interpretation from these laws we're going to be limited to what we have in by the word of the statute itself. The safety compliance facility, the applicant and each investor in the facility must not have an interest in a grower, a secure transporter, processor, or provisioning center. So again, the safety compliance facility, these are the licensees who will be testing the marijuana for compliance with the board. Lansing determines the purity and the price that a provisioning center, a grower, a processor can sell the marijuana. They determine the purity of the purity standards for the marijuana. And the safety compliance will perform those tests for a reasonable fee to make sure that those chemicals are free from residues such as fungicides and insecticides. Again, the purpose of this act is to provide the safe distribution of medical marijuana, which is now exempt from criminal and civil prosecution in the state. And again, if the marijuana that is sold from the provisioning center, from the processing center, needs to be tested and needs to be certified that it has been tested. The safety compliance facility will perform the tests that determine whether the marijuana complies with the standards. To perform other tests necessary to determine compliance with any good manufacturing practices as prescribed in the rules. They will enter all of their transactions, current inventory, and other information, again, into the statewide monitoring system that's being required under the Act, the rules, and the Tracking Act. Again, the laboratory must be a secured space that cannot be accessed by the general public. And again, they have to retain and employ at least one staff member with a relevant advanced degree in a medical or laboratory science. The application themselves. So if you want a license for one of the 5 different categories, the statute provides a pretty detailed checklist of what you have to provide and the restrictions or the actions that the applicant has that will prohibit the applicant from a license. So the application is going to obviously contain the type of the facility. It's going to provide a certain criminal history, financial information, projected or actual gross receipts, any past commercial license sanctions, identity of every person having an ownership interest in the applicant, in the facility, notify the facility that the applicant has applied for a state operator's license by registered mail. I believe that's notify the municipality that the applicant has applied for a state operator's license by registered mail within 10 days. It's got to provide a passport quality photo, a set of fingerprints for anyone having any ownership interest in the facility, and each person who is an officer, director, or a managerial employee of the applicant. They must provide a written consent to inspections, examinations, searches, and seizures as authorized in the Act. So it's essentially you're giving up your right to against search and seizure under the Act. Provide a written, so disclosure to the board of otherwise confidential records, federal and state and local tax records, credit bureau or financial institution records. And again, until June 30th, 2018, there's a 2-year residency requirement imposed on applicants. So you have to be a resident in the state of Michigan for 2 years. And if you're not, until June 30th of 2018, you will not get a license. So we've got a list of disqualifications from licensing. These are mandatory. If an applicant has been convicted of or released from incarceration for a felony under federal, Michigan, or other state laws within the past 10 years, or convicted of a controlled substance felony within the past 10 years, you're not going to get a license. No.
Is that it?
Nope.
No?
Back.
Oh, back.
Back, 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 back. There we go. All right, so an applicant who was convicted of a misdemeanor within the past 5 years involving a controlled substance, theft, dishonesty, or fraud, or responsible for violating a local ordinance in any state for any of those offenses that substantially correspond to that misdemeanor in that state, you're not going to get a license. An applicant who has knowingly submitted an application containing false information, you're not going to get a license. An applicant being a member of the board in Lansing, you're not going to get a license. An applicant who fails to demonstrate the ability to maintain adequate premise liability and casualty insurance for the proposed facility, you're not going to get a license. An applicant who holds certain public employment or an elective office, you're not going to get a license. Until June 30th, 2018, again, unless having a continuous 2-year period of residency in the state, immediately preceding the date of filing the application, you're not going to get a license. A local ordinance has not been adopted to approve the type of facility for which the licensure is sought. You're not going to get a license. And failure by the applicant to meet other criteria established by the rule, you're not going to get a license. along with those mandatory qualifications or disqualifications, the board in Lansing can consider moral character of the applicant, the integrity of the applicant, reputation of the applicant, the ability to purchase and maintain required types and levels of insurance, sources and total amount of capitalization to operate and maintain the proposed facility, criminal history of relevant offenses, including arrests, charges, expungements, pardons, or reversals of convictions, bankruptcy filings within the last 7 years, history of delinquent taxes, non-compliance with regulatory requirements in any jurisdiction, and does the applicant meet other standards or rules applicable to this license category. So again, while these are just considerations, it allows the board the freedom and flexibility to deny an applicant if the applicant has failed to provide what the board feels as a sound business plan. If they are not convinced that the applicant can create a valid business, the board may decide to reject that applicant. And it also allows, while in the renewal process, it allows the municipality to provide their input on a particular license. These are year-long licenses that and in that renewal process, the municipality can contact the board and advise the board of how the business is doing, whether it's flourishing and it's the type of facility that they envisioned, or it's struggling and there are problems with for whatever reason. So that's when the municipality has the ability to chime in on these considerations. So these licenses are a revocable privilege. This is not a property right. Granting a license does not create, bestow, or vest any right, title, franchise, or other property interest. And this is a quote from the statute. This is not mine or the city's interpretation. This is from the act. A licensee cannot sell or transfer the license without first having that other person apply for and receive the board and the municipality's approval. A licensee cannot lease, pledge, or borrow or loan money against that license. Again, this is all very similar to the liquor license laws. Like liquor licenses, the state is going to require a licensee under the Marijuana Acts to obtain liability insurance in the amount of $100,000. Before a license is granted or renewed, the licensee or applicant must file with Laura proof of financial responsibility for liability for bodily injury to lawful users resulting from the manufacture, distribution, transportation, or sale of the adulterated marijuana or adulterated marijuana-infused products in an amount not less than $100,000. The licensee cannot cancel the liability insurance without first giving 30 days prior written notice to Laura. Let me finish this. All right, where was I? All right, so the licensee cannot cancel liability insurance without first giving 30 days prior written notice to Laura and procuring new proof of financial responsibility and delivering that proof to Laura within 30 days after giving notice of the impending cancellation of that other policy. Does anyone need a break? I mean, I'm good to keep going. I've got a lot of information and all right, so we'll just continue on. I said earlier that this is a license that is to be given yearly. It is allowed for renewal. The board will be required to renew if the licensee meets all of the following requirements. Again, the application is made on a form provided by the board, which I don't believe they have a form yet available. The application was received before the expiration date of the current license. While they do allow for some exceptions and exemptions from that, all of the assessments have been paid, both locally and to the state, and the licensee meets the Act's requirements and any other renewal requirements set forth in the rules that have yet to be created. I'm sure are well in the works, and I'm sure our representative from the state maybe has some information on that. Okay, sanctions and civil fines for violations under the Act. For a transfer, sale, or other conveyance of an interest of more than 1% without prior approval, suspension or revocation or other sanction considered by the board to be appropriate. So if a licensee attempts to sell, transfer, or other conveyance, even 2% without prior approval from the board, they're in violation of the Act, and they are subject to suspension and revocation from the board. Even the attempted transfer, sale, or conveyance, again, subjects the applicant or the licensee to sanction. Failure by licensee or applicant to comply with the Act or rules or the Tracking Act, failure to continue to meet eligibility requirements for the license, or failure to provide information as requested. Again, you're looking at license denial, suspension, revocation, or license restrictions. Violation of the Acts approving the allowed type and number of facilities. You're again, looking at suspension, revocation, and the very similar sanctions. So, civil fines up to $5,000 against an individual, and up to $10,000 or an amount equal to the daily gross receipts, whichever is greater, against a licensee. This is not a bar to a criminal investigation, arrest, charging, or prosecution, and is not grounds to suppress evidence in any criminal prosecution. So if you're sanctioned and civil fines are levied against you on an administrative level, you still may be looking at criminal investigation and charges. But it is subject to the Michigan's Administrative Procedures Act. And again, an individual can be suspended without notice or hearing if the safety or health of the patrons or employees is jeopardized by continuing the operation. There will need to be a prompt post-suspension hearing to determine if suspension should remain in effect. If it does not, and if the applicant or the licensee does not make a satisfactory progress toward abating the hazard, the board may revoke the license completely. I think we missed. Go back one. Or two. Or no, maybe that's it. That's it. So, employees of a licensee. Licensee must conduct a background check for a prospective employee before that person is hired. Written permission must be obtained from the board before hiring a person who has a pending charge or conviction within the past 10 years for a controlled substance-related felony. Now, the Act does not specify whether it's a fingerprint or a name-based background check. A name-based background check is, I don't know if anyone's familiar with iChat on the Michigan State's website. It allows individuals to do a name-based background check. So after you've had your license and you've been operating 30 days after the end of each fiscal year, each licensee must transmit to the board and to the municipality the financial statements of the licensee's total operations. The financial statements must be reviewed by a state licensed CPA in a manner and form prescribed by the board. The board must submit a report to the governor and to the chair of the legislative committees that govern these related issues covering the previous year. So, this is the state's control from seed to patient or seed to destruction. They are attempting to monitor every level of production sale, use of medical marijuana. Again, the whole idea was to provide a safe means of implementing the Michigan's medical marijuana. Taxes, fees, and funding. The money. A tax is to be imposed on each provisioning center at a rate of 3% of the provisioning center's gross retail income. Tax is remitted quarterly for the preceding calendar quarter to the Michigan Department of Treasury. There's a medical marijuana excise fund that's created within the state treasury, and except for the license application fee, which we talked about earlier, which was the up to the, that's to the state, the annual regulatory assessment, and any local licensing fees, all money collected under this 3% tax described above, and all their fees and charges imposed under the act are to be deposited in that fund. All interest earnings from that fund are credited back to the fund, and the money remaining in the fund at the close of the fiscal year must remain in the fund and not lapse into the general fund. So it doesn't go back to the general fund of the state, it stays in that medical marijuana excise fund. So the money to that fund stays in that fund. The allocation of those funds, so of that 3% that goes to the state into this fund, 25% goes back to the municipalities where the municipality or the marijuana facilities are located. And they're allocated in proportion to the number of facilities within that municipality. So Michigan has 10,000 facilities in the state, and all of the 10,000 are paying 3% of the tax. And Buchanan has 5 facilities. It's going to be proportioned. Buchanan gets that that proportion of that fund. So 5 over 10,000, 25% of that. 30% to the counties where the facilities are located. Again, allocated in proportion of the number of facilities within that county. 5% to counties exclusively to support county sheriffs. This is in addition to and not a replacement of for any other funding received by those county sheriffs. $30% goes to the state until September 30th, 2017 for deposit into the general fund. But again, this doesn't take an effect until December of 17. Beginning in October 1st, 2017, for deposit into the First Responder Presumed Coverage Fund created under the Workers' Disability Compensation Act. 5% goes to the Michigan Commission of Law Enforcement Standards for training local enforcement officers, and 5% to the Department of State Police. There's also going to be a regulatory assessment to be imposed on certain licenses. All of the following must be included in establishing the assessment under this provision. Again, these regulatory assessments have not been created yet, but they are going to be directed to ensure that LARA's costs to implement and administrate and enforce the Act, expenses of the related legal services provided by the Attorney General, expenses of related services provided by the Michigan State Police, expenses of the related services provided by the Department of Treasury. Again, these are regulatory assessments that are going to be charged to the license to ensure that the regulatory functions are funded. $500,000 of that is to be allocated to LARA for the licensing substance use disorder programs. An amount equal to 5% of the sum of the amounts provided under the above allocations is going to be directed towards the Department of Human Health and Services for their use disorder prevention, education, and treatment programs. Expenses related to the standardized field sobriety tests and administering under the Michigan Motor Vehicle Code, an amount sufficient to provide the administrative costs of the Michigan Commission on Law Enforcement Standards. Again, this assessment is in addition to the initial application fee, the 3% excise tax on provisioning centers, and any local licensing fees. collected annually from the growers, processors, provisioning centers, and secure transporters. The regulatory assessment for a Class A grower license cannot exceed $10,000. Again, LARA is required to establish these assessments at an amount that is estimated to be sufficient to cover the actual costs and support the expenditures listed above. Before the date a licensee begins operating, and annually thereafter, each grower, processor, provisioning center, and secure transporter must pay to the state treasurer an amount determined by LARA to reasonably reflect the licensee's share of the total regulatory assessment established in the preceding provision. Presumably, this means that larger businesses bear the greater burden of regulatory assessment, since they may require more oversight than a smaller operation. They are going to create what's called the Marijuana Regulatory Fund. And again, this is created by the state treasury with LARA as an administrator for auditing purposes. The revenue is collected under this annual assessment, and the initial license application must be deposited in this fund. Fund interest and earnings from investments are to be credited to this fund and used only for implementing, administering, and enforcing the act. The Medical Marijuana Tracking Act. We've talked about two acts, the Facilities Act and the original Medical Marijuana Act. This is the third act passed in conjunction in December of 2016. This requires LARA to establish a statewide internet-based system to verify medical marijuana registry ID cards, monitor the Medical Marijuana Act limits, and track marijuana and marijuana products in commercial trade. It makes available to the state law enforcement and licensees as authorized to administer, enforce, and comply with this act. It requires the interface with a third-party inventory and tracking systems mandatory for licensees. This is exempt from FOIA. This is confidential information that is not available to the public. It's available strictly for the purpose of tracking, again, the seed to the patient, to seed to destruction. So it's not something that a citizen can, under the Freedom of Information Act, obtain. But the act requires that all plants, products, packages, patient and primary caregiver purchase totals, waste, transfers, conversions, sales, and returns that, if practical, are linked to unique ID numbers for each licensee, patient, and caregiver. Tracking lots and batch information, as well as products, conversions, derivatives throughout the entire chain of custody. Again, we're tracking the plant, the batch, and the product destruction, the production of the product, the patient purchase limits, and flagging of purchases in excess of those authorized limits. We're receiving testing results electronically from the safety compliance facilities, providing real-time access to information in the database to the state, local law enforcement agencies, and the state agencies, and providing the state with real-time analytics regarding key performance indicators such as daily sales, total plants in production, total plants destroyed, and total inventory adjustments. The state is really leaving no stone unturned to ensure everything is being affected and processed in a way that they see fit. Licensees must supply LARA with all relevant tracking or testing information regarding each plant, product, package, batch, test, transfer, or conversion, sale, recall, or disposition of marijuana in or from the licensee's possession or control. A provisioning center is required to include information identifying the patient to whom or for whom the sale was made, and, if applicable, the primary caregiver to whom the sale was made. And again, these submissions can be required to be provided electronically. And there are penalties for violation of the Tracking Act. A licensee who willfully violates the reporting requirements is responsible for a state civil infraction in order to pay a civil fine of not more than $1,000. A second or subsequent willful violation is a misdemeanor, punishable by imprisonment for not more than 93 days or a fine of not more than $2,500 or both. I'm trying to get through all of this, and I know there's a lot of information, and so again, the confidentiality, this is information is subject, system is established by law, is confidential, not subject to disclosure under Michigan's Freedom of Information Act. However, the information could be disclosed in order to enforce the Michigan Medical Marijuana Act and the Facilities Licensing Act. The amendments to the 2008 Michigan Medical Marijuana Act, again, these amendments took place in December of this year, 2016. Again, it amends that act to regulate the manufacturing and transporting of marijuana-infused products. It defines the marijuana-infused product, defines usable marijuana equivalent. It adds plant resin and extract to definition of usable marijuana, defines the marijuana plant and plant, amends and adds immunity provisions and prohibits certain transportation activities of qualifying patients and or primary caregivers. The goal of the act and under retroactivity, the amendments clarify the ambiguities in the law in accordance with the original intent as expressed in Section 2B of the Medical Marijuana Act. The bill is curative and applies retroactively in some instances. Clarifies quantities and forms of marijuana for which a person is protected from arrest, precluding an interpretation of weight as an aggregate weight, excluding an added inactive substrate or component of a preparation in determining the amount of marijuana, medical marijuana, or usable marijuana that constitutes an offense. They define marijuana plant as any plant of the subspecies cannabis sativa L, changes the terms medical use and use of medical marijuana to medical use of marijuana, and revises the definition of medical use to include the extraction of marijuana and marijuana-infused products. It revises the definition of usable marijuana. Usable marijuana now includes, in addition to dried leaves and flowers, the plant resin or extract of the marijuana plant. The term does not include the seeds, stalks, or roots of the plant. And I would imagine it adds plant resin or extract for the processing, for the edibles, the topical treatments now become exempt from prosecution as long as everything is copacetic with the act. Marijuana-infused product, again, means a topical formulation, beverage, edible substance, or similar product containing any usable marijuana that is intended for human consumption in a manner other than smoke inhalation. They are not considered food under the applicable Michigan and food laws. Usable marijuana equivalent is defined as the amount of usable marijuana in a marijuana-infused product as calculated under the bill. Pre-patient possession limit in order to qualify for protection from arrest, prosecution, or penalty for possession of marijuana. The Act sets a possession limit of 2.5 ounces of marijuana per patient. Combined total of both usable marijuana equivalents and usable marijuana must be considered when determining if the per patient possession limit is or is not exceeded. we are running short on time, so I'm going to,
Okay, Rick, first of all, as you can see by this very lengthy reading of all the legislation and rules, and it's a very complicated process for a grower, a person who wants to provide marijuana services to people. It's not just something that you just decide as a business person. There are very, as you can hear, very stringent rules. It took him an hour, and he's not even all the way finished. Rick, we would like you to send a copy of your PowerPoint to all of us here. Also, if you are interested, there is an online copy of this. I believe it is House Bill 4209, and that way you can kind of look at it at your leisure, circle things that you might have more questions about. You can ask us at the next meeting, but I think in the interest of time and hearing from our next speaker, we should let Rick have a little bit of a break. Good job, Rick. Thank you. Yes, that was a lot to cover. So hopefully if you're here tonight concerned that just anyone can show up in town, there is a lot of legwork and there is a lot of regulation, and the state has not entered into this lightly. I believe they saw what was going on in Colorado with legalization. Of course, that's a different thing because that's recreational use. But, you know, hopefully you can see that this is not something just anyone can jump into on a Friday night. Like, you really have to have a business plan and you have to be ready, and there's definitely lots of regulation. So I believe next we're going to be hearing, we're on agenda item 5. We're going to hear from our state representative, and Ben is going to be speaking to us from Representative Pagel's office.
I'll be very brief, and thank you for that presentation.
Can you please approach the mic? We need you on the record. Thank you.
I have to raise it up a little bit. Yeah, you're good. Okay.
That's perfect.
All right, cool.
Thank you.
I'll hunker down a little
Adjust is
bit.
right
That should
there.
be okay. That's,
Why don't you get up, Ted?
sorry, everybody.
We're broadcasting this, so we want that.
That's perfect.
There we
So
go.
we're glad this is good.
Little Gladys.
All right, all right. Well, my name is Benjamin Ike. I'm the legislative director for State Representative Dave Pagel. It's a real pleasure to be here tonight, and I just wanted to get a chance to drive down here and get a chance to listen to the presentation. And there's a lot of information here, as you're saying. And a point of clarification from the mayor: it is House Bill 4209, and it is from last session, so last fall. So if you go on to mileg.org. What you're going to want to do is search for the previous session, not the session that we're in right now, because we just started the new session this term. So if you go on there, you'll be able to find some really good resources to be able to take a look and read through this if you're more of a reader like I am. You'll see some great analysis from the Senate and House fiscal agencies. They're a nonpartisan agency in the House and in the Senate, and they just very simply say what this law is and what it does. So if you want to take a look at all of that, I'm also happy if you ever need to call the office of State Rep Dave Pagel. If you have questions as you're going through this, the phone number for the office is 517-373-1796, and we're just a small team. If Rep Pagel's not available, it'll be myself answering the phone or my coworker Tori. And if you have questions or things that come up, please feel free to give us a ring. Thank you. Next. Oh, and for the record, do you need me anything? Are you good?
Do you have a card?
I do. I'll give you that.
Okay, were there any comments from other city staff before we move on to the questions from the forums? Okay. Bill, Deborah, anything you want to add? Gladys is going to be gathering up your question forms that you were asked about. And remember, this is just regarding the law. There will be more public forums coming up next week and the week after. You're all welcome to come and then state your opinion then. Also, please, we all have email addresses. We check our email very frequently. If you don't have time to come to a meeting, your input is still very important to us. So send us an email. Let us know how we can contact you if you want us to call you back. Really, we're trying to be very transparent in this process. Yeah, go ahead.
Mayor, I just want to let you know that at Monday night's meeting, I'm going to make a suggestion of 2 dates for the public forum. These would be tentative until you approve them Monday night, but the public forum would be for, I believe it's Thursday, February 16th at 7 o'clock, and then Monday on February 20th at 7 o'clock. I'll throw those 2 dates up for suggestions to the commission to approve, but I believe it'd be prudent to get those forums presented quickly so you can hear the responses from the community.
Okay, so far we only have one question from the audience. Was there anyone else? You can approach and bring it up. Thank you. Yeah, can you just wait till after the meeting? I'll get it from you then, and we'll make sure it gets right in the pile. Thank you. Okay, I'm not sure who's going to be answering this question. I guess we'll just throw it out there, and whoever feels comfortable answering. How many grower licenses can one person or entity purchase? This is a multi-part question. Where is the rest of the Planning Commission? What is the basis for justifying the fee structure? May a non-resident be an employee of a compliance facility or a partial owner?
That was number one.
Okay, why don't we start with the first question? This is yeah. How many grower licenses can one person or entity purchase?
One.
Okay.
One license per applicant, and a person is an LLC, a corporation, a limited partnership, a limited liability, limited partnership, one license per owner, and so, yeah, one.
Okay. The second question was, where is the rest of the Planning Commission? I see we have 2 members, and maybe one of them would like to.
Third one over here.
Third one? Oh, 3. Oh, I'm sorry, Dea, you're hiding. I don't know if anyone wants to address that now, or.
I think
Oh, go
Deborah's
ahead,
going
Deborah.
to, say something.
I just wanted to state that this is not the normal Planning Commission meeting night. They normally meet next Tuesday, which is Valentine's Day. Often, some of them have other meetings on other nights. So when we moved the meeting date, we invited them to come, and we will certainly relay all of this information to them.
Okay, thank you. And then what is the basis for justifying the fee structure?
The fee structure, as far as the up to the $5,000 annual fee, is again based on the administrative and enforcement of that license throughout the year. Again, until we've had some practical application, the municipalities will have to track those expenses to adjust on the fly, I suppose, the administrative fee.
Okay. And then may a non-resident be an employee of a compliance facility or a partial owner?
A non-resident, I think it was for 2 years, cannot be a partial owner. As far as an employee, I don't know. Again, that's one of those issues that may be handled under Laura's regulations that have not been at least made public to date. And I just want to state that an issue that we're going to have with this act or any other new act, until we start actually getting out there and having having licenses and working through some of these issues are just going to pop up that the legislature just can't cover every single variable that's out there. I think they did a good job of covering a lot, but there's always going to be something that slips through, and it's going to going to have to be handled as they come across.
Okay. Is there any other questions regarding the law? We're going to, do you want me to recognize someone from the floor or no? We were going to,
Unless they have a specific question about the laws. Again, we're trying to structure this basically as a educational forum, a presentation. The two public forums that we're setting up will be everybody's opportunity to speak in favor or against the idea or the concept of provisioning centers in the city, growers in the city, the rest of the 5 segments of the delivery system of medical marijuana to the people who are licensed to have them. So, if the question is directly related to a law question, I think we're comfortable enough to hear that.
you need to approach the microphone and say your name and as well as your address, please. Thank you. We need it for the record. Thank you.
I'm William Haas, 1315 State Line Road in Niles. With the licensing, the way I read this bill, the only thing I read about not being able to have multiple licenses is you can't be involved in the transport company or the testing facility. But as far as what I read, you can have the grow facility, the processing center, and the provisioning centers. That's just the way I'm reading it, so that I don't know.
I'm going to have to look into that and to give an answer. As far as my understanding was that it was one license per applicant.
Thank you.
My name's Josh Elper. I live in 14552 Red Arrow Highway in Lakeside. And the question has to do with, the proactive nature of Buchanan related to this. Is it, I see people presenting plans and things to other municipalities. Is it too early to engage them? So you've offered email addresses and things. Is it too early to engage the municipality in direct, ideas concerning the implementation of the law?
I guess it's in a general nature. It's never too early. Nothing, even if the municipality were to authorize some sort of ordinance, it's until the license is granted by the state. The actions, the provisioning centers, the growers, they're all in violation of state law. And dispensaries, as they're called now, or any commercial activity now technically is a violation of Michigan law and is subject to prosecution. A lot of municipalities either look the other way because, again, they want to ensure the safe or at least the accessible, make sure marijuana is accessible for people who are using it for palatable and pain relief. But until the licenses are being approved, nothing can happen.
Because I'll add a little bit to that. If my interpretation of your question is, should people are already presenting plans and locations and that within the city, until the commission makes a decision to opt in, those are premature. But again, our desire is to understand this completely before it's presented to the commission for a decision about if we're going to opt in or do nothing. So until that occurs, some of this is premature. So again, the threshold is December 15th, 2017, before applicants can even apply. So if the commission opts in, there's a lot of work to do between now and then for the community. And so if they choose to do nothing, then we can at least go off of the radar screen for a lot of people so they can exert their efforts elsewhere. So, and again, we are staying extremely open-minded about this. We're trying to present the facts to both the commission, planning commission, and the community so everybody can understand what the parameters of the law is and, you know, hopefully form an opinion if we want to participate in it. So that's what I have. Anybody else?
Please make sure you state your name and your address, thanks.
Johnny Wallace, 1002 Redbud Trail. Is there any indications on what the state licensing fees will be?
Not that I've read.
Okay, we're going to hear from Commissioner Viganski.
Usable marijuana, they excluded the stalks, the roots, the seeds. I understand the seeds, but do you think that, you know, like the hemp will come back, the hemp plant? Or is it exclusively, I mean, because the hemp, you know.
That I don't have an answer to for you tonight, Commissioner.
Thank you.
Okay.
Thank you. Thank you all.
Hemp and cannabis are two completely different plants. Cannabis is, a marijuana plant is considered anything that is above 0.03% THC. Anything underneath, testing underneath 0.03% THC is considered to be a hemp plant.
Thank you.
And there's no psychoactive repercussions of a hemp plant.
Okay.
Only the marijuana plant has the THC psychoactivity.
Guess I asked a good question.
And that's what we're here for. We're all here to learn, so. Okay, any other questions from the audience regarding the law? Please state your name and your address, please.
Alan Robont, 114 East Front Street, Buchanan. I had asked the question about multiple entities, and just for clarification, if one had 5 different corporations but all owned by the same group of investors, would they only be allowed to have one Class C grower license, or would each corporation be able to obtain a separate Class C license?
You know, I guess I don't know the answer to that specifically. These statutes don't answer that question for us. I guess I have to look in and see some further research to see, better answer that question for you.
And sorry, my interpretation of your question was not how you wanted it. Sorry about that. Were you ready to speak? No. Okay. All right. Any other questions regarding the law? And again, don't forget, you can check that out. Ben gave us the address for that. And always, we are here for you to contact. We are learning right along with everyone else. We take our responsibility to city residents, their safety, their well-being, and the quality of life here in Buchanan very seriously. This is something we started on early. Niles won't even be having their first meeting until the end of the month. So we felt it was very important to get our all of our, ducks in a row, so to speak, to make sure that if we go ahead with this, that it'll be a good experience for people who may be opening, a dispensary, but also, keep the residents in mind. And, we say life is better here, but we also recognize, that people have different ways of looking at things, and we want to be open to all opinions, and your opinion matters. And if we don't hear from you, we don't know what your opinion is. So please feel free. That's very important to us as a city, our city departments, as well as we as a commission. We take our responsibility to you very important. Unless there's any other questions, we're going to call this meeting to a close. Yeah, go ahead. You can go right on up to the speaker. Thanks.
Elizabeth Hall, 808 West Front Street.
Yes.
I was just wondering if we knew for sure when there was going to be the open forum meeting, when we could ask questions, because I had heard that you said we would know at the end of the meeting.
Oh, yes. We have to decide because we all work. But we are planning on discussing that Monday, and so far, February 16th and February 20th. And
Okay.
you can probably, we will put that on the city Facebook page, so you can access that information there. And I believe we'll have to put up a notice right out here on the bulletin board. We have to make public when we have meetings. So if you don't see it on Facebook or you don't have access to Facebook, citizens can come right out there to the bulletin board.
Okay.
Okay, thank you. And what was your name again? I'm sorry.
Elizabeth Hall.
Thank you, Elizabeth. All right, and, one more person. All right, thanks. Don't forget your name and your address, please.
Rick Anstis. I'm here from Eau Claire. I basically seen what you guys are doing. I think what we're going to do in Eau Claire as well, and what you guys need here, is an informational booth, a place for all the naysayers or all the people that are just curious to go. We don't have that in Michigan anywhere. You can't just go and find out about medical marijuana. It's still covered up, So we need to get that open out there, because in my experience, not every naysayer I've ever come across has turned their head, but many will, because when you see the applications, especially in children, you're not human if you don't see its applications. When a child's seizing and stops in a matter of seconds and could have quite easily died, it's a miracle, So it needs to be looked at it that way. There's a lot of applications, not just seizures, rheumatoid arthritis, MS. It goes all the way down to a headache. And I know a lot of people, as this ball has been going, has thought, well, they're giving out marijuana cards for anything. It doesn't matter. Well, it actually is better than taking aspirin, period. No side effects. They've already found aspirin to cause heart issues. So
Okay.
I think
I'm
the
really sorry.
information.
We are.
Yeah, sorry,
Go ahead. You
Yeah.
can come to the next meeting and tell us all about that. But
Sure.
we are keeping our comments tonight to the law, so I'm going to have to cut you off. Thank you, though.
Basically, I think that you guys should implicate an informational place
Yes.
to get information.
Excellent. And you can bring that to our next meeting. That would be very helpful to this process. And with that, we're going to adjourn this meeting. Thank you, everyone, for coming. And please, we need to know what you think. Thank you.